I have to say that I have to apologise for how cold the court is. This is a very unusual apology to have to make. But I've done my best with the knob, which won't move. Anyway, so we'll just have to huddle together. Mr. Capt.
I'm grateful, my lady. So I'll move on to implied rescission, which is the main aspect of our respondent's notice. And I picked this up in my skeleton at paragraph 66, skeleton behind time before. For context, the implied rescission argument was one of Capt. Frangos' alternative cases at trial. His two primary cases on construction were not accepted. At a very high level, the gist of the argument is that the TTA was subsequently overtaken by later events, and those events are fundamentally inconsistent or irreconcilable, properly viewed, with Capt. Frangos and Miss Frangou having had a continued intention that the TTA subsist as a contract. And in fact, we say the later events are only consistent with them having agreed to impliedly rescind the TTA. And the two documents that will be the focus of focal points of my inquiry today are the MEH letter, which is the settlement of the trust, which you've heard about before, and something called the 2018 reconciliation, which I'll also take you to in due course. First of all, I want to address you on the legal principles in this area, and then I'll go on to apply those principles to the two time periods in question. I set out the legal principles as I contend them to be at paragraph 68 of my skeleton. And I'm going to make these good, these propositions, by taking you to some authorities in a moment. But just to summarise before we get into them, paragraph 68A, the primary inquiry here that we're about to undertake is to identify a separate implied agreement between Party A and Party B to abrogate or abandon a prior agreement between them. And I'll call that prior agreement, for ease of nomenclature, Contract 1. And in this case, the task is a search for an implied agreement between Capt. Frangos and Miss Frangou to abrogate or abandon the TTA, or at the very least, Clause 5 of it. And in this context, the TTA is my Contract 1, the original contract. Paragraph 68B, much of the case law in this area is focused with discerning the intention for the implied agreement to rescind from a second or later contract between the same parties who concluded Contract 1, dealing with the same subject matter. And that classic scenario, that second contract, I'll refer to as a Contract 2. So the classic application of the law in this area to this case would be a second contract between Capt. Frangos and Miss Frangou, which deals with exactly the same subject matter of the TTA and is only consistent with them having had an implied intention to rescind the original contract, the second contract properly construed. But important to note in the analysis here is that the implied agreement to rescind that is evident from the later situation takes form as a third contract. So there's a Contract 3 as well. It's a one-term collateral contract to the later event to rescind Contract 1. And that way of analysing the implied rescission agreement as a one-term collateral contract was accepted by the judge at paragraph 97 of his judgment. So in my submission, in the cases where there is a Contract 2, which is said to demonstrate an intention to rescind Contract 1, there are actually 3 notional contracts in play, not just 2. So a Contract 1 at the first point in time, and then 2 parallel contracts, a Contract 2 and 3 at the later point of time. And I say that my learned friend doesn't agree with this in their supplementary skeleton at paragraph 6. And in my submission, that's inconsistent with the judge's findings, and I'll show you why the judge's decision on this was correct. And as we go forward in this part of the case, it's very important to always have in mind which of the 3 contracts we're talking about if we're dealing with a 2-contract situation or a 3-contract situation, because different principles of interpretation will apply to the different types of contract. Paragraph 68C, while having a classic contract 2 might be very helpful to an implied rescission case, and it might be a textbook example of how the doctrine can arise. In my submission, you don't need a contract 2 at the later point in time in order to infer that a contract 3 has come into existence. That contract 3 being the one-term collateral contract to rescind contract 1. And to focus only on the permutation of a two-contract situation loses sight of the core principle at play here, which is the ascertainment of the mutual intention to rescind. And a contract 2 situation may be a paradigm vehicle through which you can ascertain an intention to rescind, ascertain the intention to form that contract 3, but it is not the only vehicle through which you can understand that that type of intention exists. So I'll go forward to make good those propositions in the cases now. The first case I'd like to take you is to the Cobalt Data Center case, which is the decision of this court. It's in tab 13 of the authorities bundle. It's a very recent case.
Well, it's not all that recent, and it is in fact also reported. It's in Simon's tax cases.
I apologise for not having picked that up.
2022 STC 2041.
I apologise for only having the transcript in here, and that was an oversight. As you've identified already, my lord, this is a tax case, and the factual matrix is fairly knotty. I don't think we need to delve into it in any detail, but in summary, the tax dispute arose in the context of the construction industry and certain tax breaks that had been offered to encourage development in disadvantaged areas of the UK. And the aspect of the dispute that's relevant to us was whether two change orders issued in relation to the building project were so substantial that in effect two new contracts, with the effect that they impliedly rescinded the earlier building contract. And the reason why that was relevant in this case is if the later change orders did rescind the original building contract, such that they were new contracts in themselves, they fell outside of the date range, or the time frame, for the appellants to have been able to benefit from the relevant tax breaks. So it was a question, that was really the question that everyone was interested in. You can see that the key issue was summarised at paragraph 37.2 of the judgment by Lord Justice Lewison. It summarises what I've tried to explain. The relevant law on implied rescission was covered by both Lord Justice Lewison and Lord Justice Newey, but I'm going to take you to the summary by Lord Justice Newey because it's very focused. And that's at paragraph 135 of the judgment. And although it's focused, it does cover some pages. I just would like to ask you, my lords, to read some selected parts of these 2 pages, which I'll, before I continue. And please could you read paragraph 135 and 136, Roman 1, Roman 2, Roman 3, Roman 4, and Roman 7 over the page. And I appreciate that's quite a lot of reading, but I think it will help rather than me talk it all through. my lords, stop me if I'm starting too quickly, but I've got 4 points that I would ask you to take from the passages I've asked you to read. In particular, by reference to 136 Roman 2, the emphasis on the inquiry here is the ascertainment of intention. And in my submission, the prominence of the search for intention should not be restricted by form, the form in which you can ascertain that intention, whether it be from a second contract or otherwise circumstances and events from which you can ascertain objective intention. There should be no formal restriction on where you can look and what sort of document you can look at in order to appreciate that intention. And that's relevant here.
I thought the proposition, or thought your proposition was that what we're looking for is an implied contract, that the first contract be rescinded.
It is.
So I thought you apply the same principles of contract law to the question of whether there's a contract, and if so, what it means.
You do in relation to what I've termed contract 3, the one-term collateral contract to rescind. My learned friend's position is that you can only look for the intention to form that contract 3 from another contract.
Right, okay.
So he says...
And you say that's the vanilla version,
That's it.
but you can find your intention anywhere.
Yes, and the reason this is relevant is he says the MEH letter isn't...
Right, but it's not just intention, it's contractual.
Yes.
Sorry, it's intention, so it has to be in the form of a third agreement.
Yes.
To rescind the first one.
Absolutely. But you're not restricted on looking...
Second stroke third.
Yes, you're not restricted on looking for that intention for the third contract, the rescission contract, only in
another contract.
Exactly.
Yeah, no,
That's the point.
You are looking for an agreement.
Yes.
Of some sort.
An implied one. So you're not going to ever find it written. You're not going to find that agreement written down. Otherwise, it would be an express contract to impliedly rescind an agreement. So you're having to infer it from the circumstances that are in front of you. A classic case where you might infer it is if you do have a separate contract that deals with the same subject matter as the original contract, and you might say, well, look, this is so inconsistent with what the first contract said, I have to infer that there was an implied agreement to rescind, which takes the forms of a contract 3. My learned friend says that's the only way you can ever get this doctrine off the ground, and I disagree with that as a matter of principle.
Okay.
So I'm showing you that passage of Lord Justice Newey's judgment to show that the focus is on intention. It's not being formally restricted in any way there. Although he wasn't seized with this question that arises in this case. It only goes so far. My second point from what I've asked you to read is that I entirely accept the process of ascertaining intention for the rescission contract is an objective one, but you are entitled to look at all the circumstances surrounding the point at which you say an implied agreement to rescind comes into effect to inform one about the likely status of the intention on that day, a bit like you would be able to look to background factual matrix in relation to any contract. It's the same sort of principle. My third point is a helpful way to look at the task at hand could be to ask whether the later situation, the agreement or the trust document in our situation, was intended to, in effect, initiate new relations between the parties. And for that, you can see the quote from Viscount Haldane reproduced at paragraph 135, Roman 3. And that might be a useful tool to use later on. And then fourth, I just want to draw your attention to one of the quotes from Lord Atkinson's speech in Morris and Brown that Lord Justice Newey reproduced in 136 Roman 7, just by the second hole punch. And it's the phrase that you're looking for just above the second hole punch, that you're looking for the clear intention of both the appellant and the respondent to put aside in their future dealings the original agreement and treat it thenceforth as abandoned or non-existent.
Sorry,
I can't find it.
It might have, so yes, my Gina's helped me to find where I was really reading from. It's in 136 Roman 2.
Thank you.
Just above the first hole punch. A quote from Lord Atkinson. And in my submission, that's a useful cross-check, although of course the overall process is much wider than just these small phrases. And what I'd like to just spend a little bit more time on before I move to application is my submission that you don't need a second contract per se, out of which to infer the intention for your implied rescission agreement. And my lords, you can see that from the Morrison-Brown case in the bundles behind tab 1, which is a Privy Council decision from 1912, and I think treated by both of the parties as one of the originating or oldest cases discussing these principles in any detail. And this was a case in which a contract for the sale of wool was argued to have been impliedly rescinded by a later parole agreement purporting to settle litigation that had arisen in respect of the original sale contract. So in this case, the sale contract for wool is contract 1, and the parole agreement settling the litigation is the equivalent of the contract 2, and it was said out of contract 2 you had an implied agreement to rescind contract 1. Now, one of the defences to the claim for payment under the original contract was the assertion of a counterclaim under the parole contract. And that counterclaim, insofar as it was relied on in the parole contract, failed as a defence in the Court of Appeal because the parole contract had fell foul at that time of something called Section 4.1 of the Sale of Goods Act 1893, which at the time required contracts for the sale of goods for over £10 to be in writing, a bit akin to the statute of frauds. And the ultimate effect, if your agreement for goods over £10 was not in writing, was that it was unenforceable. And that was one of the issues in this case. And one of the major debates in the speeches of the law lords was whether it was possible in relation to a contract that was not enforceable for falling foul of Section 4.1 of the Sale of Goods Act, as the judges had found the parole contract had done, whether it was possible from that kind of contract to infer an intention to rescind the earlier sale agreement. And the answer was yes, it was. And you can see Lord Finley's conclusions about this at page 12 of the report. Just by the first hole punch, the line that starts option instead, if you read from under these circumstances.
I'm sorry, I'm on page 12 of the report.
Of the report.
And then you took me to...
Yes, so just by the
under
first...
the circumstances.
Yes, just by the first hole punch. If you were to read down to where the words Noble and Ward appear, this makes good what I've just said. I'm going to go back to that and show you this more clearly from the other side.
Oh, yeah, I'm sorry. Page 14 of the bundle.
Yes, sorry.
Under the circumstances, yeah.
I'm happy to use one or other of the references.
Yeah,
you tell me which you prefer.
Page,
yes, so, and I'm going to revisit some of the other Law Lord speeches which make the same point, because the nature of these old decisions, they're all slightly, they will say things in a slightly different way. But this is where Lord Finley deals with the point I've just been telling you about. And just because we're here, although not exactly related to what I'm talking about, could you also read from the second hole punch of the bit of the speech you're looking at across to the end of the paragraph over the page, because that's relevant more generally to the task we have. What I just want to draw out from this second passage is two relevant concepts which I'll return to later on that Lord Finley was impressed by in this case, and that's his observation that the parties' dealings and correspondence subsequent to the parole contract were premised on the basis that the original contract had been set aside. And that was important to him, and that indicates that you can look forward in time beyond the time period you're saying the implied rescission has taken place to aid you in your understanding of whether that implied agreement was agreed in the first place. And that's an entirely orthodox principle of contractual construction, which I'll return to. And the second point is he was also impressed right at the end of the paragraph going over the page by the idea that neither party had ever referred to the original contract after the parole contract had been entered into. And as may not have been made clear so far to you because it's not been relevant, that is a feature of this case as well, because as it was found by the judge to be, the TTA was not referred to in correspondence with the party, between the parties at any point after October 2012 until the claim reared its head in 2020, and we say that's a significant factor. It fell into a black hole, as the judge described it in the judgment. But returning to the theme I was primarily talking about.
So how does that fit? You say you can look at the conduct of the parties after the date on which it is said that they agreed to rescind the first agreement in order to decide whether, as a matter of law, they had in fact agreed to put an end to the first contract.
Yes, you can't look at post-contractual conduct to influence the meaning of a contract, but you can look forward to post-contractual conduct to inform whether an agreement was reached at all in the first place. And that's, I think, orthodox authority, and I'll take you to a judgment from this court to that effect in a moment. But that's the point there. And it's again demonstrated in this case elsewhere, as we'll move on to. But still on the theme of the decision in this case that an unenforceable contract could still form the basis for an implied rescission is next the judgment of Viscount Haldane on page 18 of the report. And in this instance, could you read from about 1 inch above the first hole punch the sentence that starts, "It was not decided," through to the end of that paragraph?
Page 18 of the judgment.
Page 18 of the report. From the words, "It was not decided," about 1.5 inches above the first hole punch, down to the end of the paragraph. And here Viscount Haldane is explaining that even though a contract may be unenforceable, the relevant question is whether nevertheless there is an intention to rescind that can be gleaned from it, independent of any further intention which may exist to substitute or create a second contract. My lords, the logic behind this analysis is that the putative second agreement here, the parole agreement, while not enforceable as a contract, remains a source of evidence as to party intention, which is admissible as an aid to construing whether or not the separate implied collateral to agreement to rescind, contract 3, has been reached. And as I'll show you later in the judgment here, that's why the law lords in this case go on to draw a distinction between an ability of a non-enforceable contract like this parole agreement to vary contract 1, the original contract, or rescind it. And they decided that a non-enforceable contract couldn't vary contract 1. And my lords, that must be thinking about it, because with a variation argument, you're relying on contract 2 for its contractual effect to modify the terms of agreement 1. And that's why an unenforceable contract doesn't work for you. But when you have an unenforceable contract and you're looking at implied rescission, you're not relying on the second contract for its contractual effect vis-a-vis the original contract. You're relying on it as a source for the intention to form a third contract, which has the effect of rescinding the original contract. And we can see this reasoning inherent in Lord Dunedin's speech at page 26 of the report. And all of this debate was taking place in the lordships, in their lordship speeches, by reference to a case called Noble and Ward, and what it meant, and whether that old case drew a distinction between the effect of an unenforceable contract when it was used to vary and when it was used to impliedly rescind. And Lord Dunedin concludes just by the second hole punch on page 26, if you could read from the words, "This brings me to the third view," down to the end of that paragraph. My Lord, in trying to understand, my Lord, trying to understand why a distinction is being drawn here, the reasoning is, as I have suggested to you, that when you're looking for an implied rescission agreement and you're looking at a second contract, you're using that second contract as a source of intention, not for its contractual effect itself. Back on and taking that to its extension, if you don't need an enforceable contract to look for your intention, and you're not relying on the second contract for its contractual effect, why do you need a second contract at all? You don't. You can just look to any other relevant and admissible sources of data from which you can infer whether an objective intention existed at a single moment in time for contract 3 to be formed. And then finally, before I leave this point, is a similar point made by Lord Parmore at page 36 of the judgment. And it's from the beginning of his speech up until the words April 1915, about 7 lines down on the top of page 37. This is quite a neat summary of what I've been explaining to you as the situation in this case so far. To return to the question Lord Justice Snowden was asking me, also in Lord Parmore's speech at page 38 of the report, if you read from 4 lines down, halfway through the line, the words "it is necessary," to the words just below the first hole punch, "subsequent acts and conduct," this demonstrates that you can look forward in time from the second contract, the putative implied rescission stage, to inform whether the implied rescission was agreed. My Lord, so insofar as my learned friends say it's not permissible to look forward in time, which they do say they're wrong about that, I made this point in my skeleton by reference to a Court of Appeal case, GNER and Avon Inns, which we have in the bundles behind tab 6. If you want any more reassurance about this proposition, my Lord, you could very quickly turn that up because it's just one paragraph to read. It's tab 6 and page 29 of the judgment, where the point's put beyond doubt.
I'm sorry, where is it in tab 6? You want us to know?
It's paragraph 29, please, my Lord. Now, what is very important discussing this is, as I said before, always to be clear which of the contracts one is talking about, particularly when looking forward in time, because I completely accept, let's say the MEH letter was a contract, we couldn't look forward in time to aid our interpretation of the MEH letter if it was a contract. because that would to aid the inquiry into the meaning of that document. But when you're talking about the collateral agreement that it comes into existence at the same time as the MEH letter, you can look forward in time to subsequent conduct to inform whether that agreement was concluded. So I'll always be careful to try and keep that demarcation in my submissions to you. So, my lords, having looked at the law, time to turn to what the judge decided about the implied rescission case. And his analysis of this case, part of the case, starts at paragraph 94 of the judgment. And just by introduction, at paragraphs 94 to 95 of the judgment, the judge explains that because of his decision in Captain Frangos' favour on the construction points, he doesn't need to decide the implied rescission case, but if he had been required to, he would have not been persuaded by it. And then at paragraph 97, the judge sets out his understanding of the law. Now, based on the cases I've just taken to you to, we say that the first sentence is wrong because the judge falls into error in finding that one has to have a second contract between the parties on an inconsistent basis in order to get an implied rescission case off the ground. But we support the second sentence of this paragraph, where he goes on to conceptualize the implied rescission agreement as a separate collateral contract, standing next to the putative second contract, although he was incorrect about how he looked at that. Then the judge moves on to application of the legal principles at paragraph 99 of the judgment. At the trial, the implied rescission case was advanced across 3 date points, or 3 events, which included the parties' acquisition of the Orion 3. But upon the appeal, we've narrowed down the case on implied rescission so that that no longer forms an independent ground of the implied rescission case, and we're focused on the MEH letter and the 2018 reconciliation. And the judge deals with the MEH letter at paragraph 100 onward, paragraph 100. And the judge's points can be broken down as follows for why he declined to accept the argument. First, the judge noted that the MEH letter, which we'll be looking at very shortly, is not an agreement between Miss Frangou and Captain Frangos at all. Now, insofar as that was the judge taking a point about the need for a contractual agreement, as he had explained in the first half of paragraph 97, well, he was wrong about that for the reasons I've already indicated. Insofar as he, by those words, was indicating a point about the MEH letter not being possible to infer from the MEH letter what the intentions of Captain Frangos and Miss Frangou were, again we say that's wrong, and I'll take you to why that was an unsafe decision in due course. Then the judge moves on to his key finding after those introductory points. And he says the document is not necessarily or fundamentally inconsistent with the survival of the TTA, and he conceptualises the effect of the MEH letter as an undertaking by the trustee to do certain things in relation to the assessment and distribution of profits in relation to the TT and 5 other vessels, but he says he doesn't think that's anathema to the TTA's survival, and we disagree with that conclusion, as I will come on to. Then finally, in the last words of paragraph 100, he says it is legally possible for clause 5 of the TTA to subsist in parallel with the MEH letter arrangements. And my lords, we say that comment as a matter of principle puts the test too high. The bar when it comes to implied rescission is not total legal impossibility. It's whether objectively ascertained the parties would have intended the earlier instrument to subsist in light of the later circumstances or instrument relied on. Now, of course, complete legal incompatibility across 2 successive contracts or instruments dealing with the same subject matter would be a strong factor in support of an implied rescission case, but to make that the benchmark finding puts the test too high.
But if you're looking for an implied agreement, don't you have to say that this is the only the only explanation on the facts is that there is an agreement to rescind.
Yes, but that might not be a conclusion you reach through sheer legal incompatibility. It might be a conclusion you reach because the second agreement is significantly inconsistent with the primary agreement, such that, read in the round, it can't have been the party's intention for the first agreement to persist, even though it isn't completely impossible. That puts the test too high. And if the citations from Lord Justice Newey in the Colbert data case don't go that far when you really look into them, they sound like phrases like fundamentally inconsistent sound like a very high bar, but they're not quite at the stage of complete legal incompatibility. It's about something going, in some of the other citations we put in, it's about something going to the very root of the original contract. If it's really affected the prime essential purpose of the first agreement, you might still infer that the first agreement has been impliedly rescinded. Again, this is all about giving effect to party intention, and so we say that the way the judge was looking at this was too strict. That's all the judge said about the MH letter point, and then he goes on to deal with the 2018 reconciliation over the page, which I'll come back to when I deal with that, because I'm going to apply the law in 2 stages.
Just to be clear, the test you say is the one at 97, subject to the point that it doesn't need to be a further contract.
Yes. Yes.
Yeah. Okay.
So staying with the MEH letter and applying the law we've just been through to that document, and this is building on submissions at paragraph 70 of my skeleton. The MEH letter is in the supplementary bundle at page 570. I've written down the wrong tab number, which is why I'm not...
26.
26, thank you very much. I wrote down 62. So it's tab 26, page 570. Now, first to tell you some common ground about this letter. Everybody agrees that this letter constitutes the settlement of a trust by MEH, and everyone agrees that the same principles as apply to the interpretation of a contract also apply to the interpretation of a trust document. And it's for that reason that we agreed, pursuant to the practice direction 52C, not to include the authorities in the authorities bundle, which I've cited at paragraph 70 of my skeleton to that effect, so we didn't overburden you with authorities about principles that aren't in dispute. Now, at the top of this letter, you can see it. The letterhead is MEH Holdings SA of Panama. That's the trustee, and the letter is addressed to 2 corporate vehicles, Prosperity Overseas and Sangamo Corp. And it's also common ground that Prosperity is Captain Frangos' corporate vehicle. He was at the time of this letter the beneficial owner of Prosperity, and Sangamo is Ms. Frangou's corporate vehicle. And you can see below the addresses, you've got a list of 6 vessels that the letter that MEH refers to the acquisition of these 6 vessels. And the first one on the list is the Taurus 2, and then there's 5 others. And, so that's the subject matter. And then you get down into the substance of the document below the list of the vessels. And in subparagraph A, having listed out Brandon as one of the companies that's being spoken about, MEH says, we confirm and undertake that we hold so far and shall continue to hold all the shares of the said corporations in equal parts for each of you. Now, we say that the folding of the TT into this arrangement, into this framework, constituted a fundamental change in the parties' dealings by moving the TT and how its profits and losses were to be treated and split up and allocated between ultimately Captain Frangos and Ms. Frangou, away from its previously siloed location under the TTA into a 6-vessel 50-50 joint venture structure.
Sorry, Can you repeat that? Sorry, can you just repeat it? Because I thought you started talking about moving the TT, the vessel. This is all to do with the holding of shares in Brandon.
Yes, so moving the company Brandon, which owns the TT, into the relationship that you see this letter creates is a fundamental change in the way the parties were dealing with Brandon and the profits and losses that Brandon was to suffer or profits that it was to make.
It's just dealing with it's just dealing with the beneficial ownership of the share capital.
Well, as we continue, we'll see it does a little bit more than that, because it doesn't just stop at splitting the beneficial ownership. It begins to talk about how the profits and losses from those vessels, from the companies, are to be split up and allocated and divided.
And it deals with each of the companies which owned each of the vessels which are set out above.
It does. So perhaps jumping ahead to paragraph C, my Lord Snowden, MEH indicates that it will keep both of the beneficiaries fully posted regarding any matters related to the above. And we shall not take into account, insofar as the assessment or distribution of profits or losses is concerned, any proven unequal cash contributions in the form of equity or loan by any of you, or your affiliates, or advances by the manager in relation to any of the ships which might be disposed at a future stage. And the starting point, we say, from this arrangement is that the expectation of a 50% beneficial owner of the shares in each of these companies would expect an entitlement to, if the vessel has been sold and there were net profits realised at the end of that process and the company was about to be liquidated, the 50% beneficial owner of that company would expect to receive a distribution of 50% of the net profits as the residual creditor of that company, one of the residual creditors of that company. That's the starting point. But what paragraph C does is say, well, when we get to that stage when all of the vessels are sold, what we'll actually do is look across to various other different things to decide whether or not you do get your prima facie entitlement to a distribution, because we might change it by reference to various things. So equity or loans that have been provided, advances to the manager, which is MEM, the company we've been talking about a lot over the last days, advances by the manager, which one might equate to funding by the manager that has been put into the company.
I'm sorry, I'm going to have to. I'm just struggling to. I can't take on board what you're submitting and relate it to the words that I see on the page in front of me. Which words are you actually looking at? I mean, which words are we focusing on as a manifestation of some intention?
Paragraph C of the...
Right, so that we shall keep both of you fully posted regarding any matters related to the above. That's what? The shares?
Yes, and the creation of the trust over the shares.
So, and in particular, we shall not fail to take into account, insofar as the assessment and or distribution of profits or losses is concerned, that's presumably on the shares, any proven unequal cash contributions in the form of equity or loans by any of you or your affiliates, or advances by the manager in relation to any of the ships which might be disposed of at a future stage. Can you actually... I mean, I'm struggling to understand that language. I mean, is it just saying we acknowledge we hold shares for you 50-50 beneficially, and we as trustee will keep you as beneficiaries posted about any distribution of profits?
That will ultimately...
I don't know how you distribute losses, but anyway.
Well, that's an interesting point, because what we say this letter envisages is that losses suffered by one of these ship-owning companies could be set off within this structure against profits made by another ship-owning company covered by this letter. to lead to an overall distribution collectively, taking into account the overall position across the fleet. And as I'll go on to show you, that is precisely the intention that Ms. Frangou had, subjective intention albeit, so it doesn't mean that that's necessarily what's been created in this document, but that is exactly the intention that Ms. Frangou had that this document would achieve. So,
I'm afraid I read it in a completely different way, and so I'd be grateful for help in relation to C, because it's saying we'll keep you posted, and we won't fail to take into account, insofar as the assessment and or distribution of profits or losses is concerned, any proven unequal cash contributions in the form of equity or loans that you may have made, or your affiliates may have made, or advances that you have personally made to the managers in relation to the ships, which might be disposed of in the future. So that is, in effect, isn't it, preserving the differential in the sense of I, brother or sister, have paid or I am responsible for a large chunk in relation to that ship. And what C is saying is we, the trustees, won't forget that at the final point when that ship is sold. I.e., it's preserving an unequal situation, isn't it?
It's preserving an analysis of the situation in relation to each of the companies in parallel, but then saying before we ultimately decide what you're entitled to be paid out as the beneficiary of this trust, there'll be a mixing of the positions across the 6 vessels, leading to an overall net amount to be distributed to you or not. That's our submission about what it means, but more important, as I'll come on to show you, is what Ms. Frangou intended it to mean, because that sheds light on what her intention with respect to the TTA was at this time.
Sorry, how can her own evidence of what she personally intended be relevant, given your acceptance it's an objective inquiry about intention?
Because her evidence about, well, we'll look at it, but her evidence about her intention goes to what she intended the MEH letter to achieve. And that doesn't inform us about the question of whether she actually achieved what she wanted with this letter. But you can infer passively from her intention with respect to this document what her intention with respect to the TTA may or may not have been.
Isn't this again looking at the subjective motivations, which is what we're forbidden to do in an objective inquiry? I mean, you're constantly trying to have your cake and eat it, if I may say so. On this point.
I hope I'm not doing that.
I'm sorry, I don't mean that offensively.
What I'm trying to do is, in my submission, it's orthodox to be able to infer something about someone's objective intention about one thing from their subjective intention about something else. Because you can infer something about another topic that they're not discussing by reference to what they are saying about something else. I think that's, in my submission, that's orthodox.
So are you saying that what this means, this clause C means, is that this is a trustee saying to the people for whom it holds the shares of Brandon on trust, if the Taurus 2 is sold, when it comes to making any distribution of profits to you, the two of you, because we will receive a distribution of profits from Brandon to ourselves as shareholder, and we will distribute those profits to you we will take into account any unequal cash contributions that you previously made, or your other affiliates or otherwise, in relation to the ships.
Yes.
Okay. So, in other words, what, to adjust, to do what? I don't really understand what they think they are doing.
Well, my lord, let's have a look at that. And I take Sir Launcelot's point that it may, in your judgment, not ultimately be relevant, but let's have a look at exactly what they thought they were doing. If we can look in Miss Frangou's second witness statement from trial behind tab 12 and to page 171 of the bundle, and if I can ask you to, if you have time to get it, I'll ask you to read paragraphs 56 to 60. This is Miss Frangou's statement.
56 to 60.
Yes, please.
Thank you.
At once.
It's at page 171 behind tab 12. My lord, a few points to make about what I've asked you to read. Paragraph 56 in my submission indicates very clearly that the MEH letter is a product of Miss Frangou's intentions, so it's perfectly acceptable, even though the entities named in the MEH letter are not Miss Frangou and Captain Frangos, to ascribe to whatever the thinking behind the MEH letter was, or to trace it back to Miss Frangou's own intentions. So any suggestion that the MEH letter, from the MEH letter, you can't infer Miss Frangou and Captain Frangos' intention in order to get an implied rescission case off the ground in my submission isn't a good one. Then in paragraph 57, just by the second hole punch, Miss Frangou says, "I knew that there was no prospect of John advancing monies to fund any losses sustained by the vessels." Well, this is an explanation of Miss Frangou's motive behind wanting to move the TT into the MEH, move Brandon into the MEH letter structure. She did not think back in September 2017 that Captain Frangos was going to be able to fund any losses suffered by the vessels, including the TT. And so her thinking, evident from this statement, is that in order to have a chance of protecting her position, she needed to change the structure in which the TT existed. And so she decided by moving it into the structure you see in the MEH letter, she'd be able to offset losses that might notionally be suffered on the TT that she would never be able to recover from Captain Frangos by way of an indemnity, by instead setting them off against more profitable vessels also contained within the MEH letter structure. So this, in my submission, supports an idea that at this stage she had no intention that the TTA was to remain the route by which she would pursue Captain Frangos for any exposures she had in relation to the TT. She continues from where I left off. This was a 50-50 arrangement where in practice I would be left carrying all of the losses and John would share in the profits if any ultimately were made. This is inconsistent, we say, with her at the same time holding an intention that Captain Frangos was to be responsible for all of the losses. She's accepting that there's a 50-50, she's looking towards a 50-50 arrangement to be created in which they would share equally in the profits and responsibility for losses in relation to each of the vessels that were to be included, or the companies that were to be included within the MEH letter wrapper.
Well, I don't really understand what, why you're saying that this document necessarily connotes the giving up of the arrangements or the discharge of the arrangements under the TT agreement. I mean, Angeliki had the ability to pursue, prior to this document being entered into, she had the ability to pursue her brother under the TT2 agreement. Yeah. I mean, there's no guarantee that he would necessarily pay, but she had the ability to pursue him. This, as I understand it, is saying before the trustee distributes monies to these people for whom it owns these various shares, it would make various adjustments. Why, for example, couldn't this simply operate such that if, for example, John had not paid up under the TT2 indemnity, but there was money which would otherwise be due to be distributed to the two of them in relation to one of the other companies, that would simply be, as it were, recouped. In other words, the fact that he hadn't paid under the TT agreement would be recouped from surplus monies that were otherwise to be distributed by the trustee from one of the other ships, or vice versa. I mean, isn't it a sort of netting off provision? But why does the specific agreements in relation to any one of these vessels fall away implicitly? That's really the question.
Because the arrangement that she intends becomes the vehicle through which she is going to look to Captain Frangos, or through which the ultimate position between them is going to be reconciled, rather than independently through the TTA, separate through all of this. She's moving away from the TTA because she doesn't think she'll be paid anything under it ever, because she doesn't think Captain Frangos would be good for the money, to a new structure, a new legal wrapper to regulate their rights and liabilities.
But why does she have to give up the prospect of him paying? He might. It's just that if he doesn't, as it were, she has the ability to have recourse to funds which would otherwise come to him to make good his default.
Because at the same time as this arrangement is affected, the beneficial ownership in Brandon is split. So the overarching impression one gets from looking at this structure is that she's trading off having a contractual right for 100% of the losses that she thinks is commercially worthless, for a 50% right to be effectively indemnified for those losses under this structure, in return for the benefit of now being able to set off her exposure to those losses against profits available on other vessels that she wouldn't otherwise have had if she'd kept only her 100% entitlement to an indemnity under the TTA. So she's sort of calling it quits on the TTA, saying, well, I'm never going to be able to enforce that obligation, so I'll give up 50% of my beneficial ownership in it. That notionally entitles Captain Frangos to a 50% share of the profits in that company, but I know there's never going to be any profits, so I'm not too worried about that. And in return for that divestment and beneficial ownership, I get the benefit now of being able to set off my reduced entitlement to loss is okay, but I actually get to make good that notional loss because now I can set it off against his 50% entitlement to profits, let's say, on Tina 4, one of the other vessels. And she can't do that without this structure. And you can see this sort of thinking implicit in her in her observations in this statement at paragraph 58 over the page, at the end of 58.1, when she's talking about Brandon being moved into this structure. She says, consequently, there was no prospect of a 50% equity interest in Brandon having any value. Becoming a 50% shareholder in a company that was facing severe financial distress was a burden, not a benefit. This was her thinking behind giving up her 50% share in Brandon to Captain Frangos. She was lumbering him with an obligation to be responsible for 50% of Brandon's losses.
We keep saying he's not responsible for 50% of losses. I mean, there's a bespoke arrangement dealing with the bailout and the TT2 agreement, which relates to Brandon and Taurus. If John abided by the agreement, then it's undoubtedly the case that the effects of the bailout would be unwound, to whatever extent it was agreed it should be unwound. But if he didn't, then isn't she effectively saying that this is an agreement by which she has further protection, because the trustee would intercept, if you like, or would otherwise be a distribution to John, to equalise or make good the position of the parties? I mean, I'm just...
Yes.
I mean, and she doesn't see this evidence suggests that she, to the extent it's relevant or admissible, she doesn't see any prospect of Brandon producing a benefit. It's always just a deficiency.
But a deficiency in respect of only 50% of... She's now seeing Captain Frangos as encumbered by 50% responsibility for Brandon's losses. If you look at the words she uses, becoming a 50% shareholder in a company that was facing severe financial distress was a burden, not a benefit. Well, what burden is she talking about? She's talking about the ultimate burden of having to fund 50% of the losses of the company. How is that consistent with her at the same time having an intention that Captain Frangos be responsible to fund 100% of the losses of Brandon?
I mean, that's the ultimate question, isn't it? Is this arrangement additional protection, or does it replace the previous protection?
I agree. In my submission, it's replaced. If you look at paragraph 59, she says she's never entered a 59. She's never entered into a 50-50 venture where one party has no responsibility to contribute to funding the losses. Well, how is that consistent with her at the same time having an intention that that Captain Frangos has an obligation to fund 100% of the losses? She considers, her intention is that a new joint venture has been engaged in here to replace the earlier structure, where there are trade-offs and there are benefits and there are for her.
So where do we find the attitude of John, your client, to all of this? After all, if it's going to be a replacement of the initial contract, it's got to be one which they're both in.
Yes, it's never been contested that what we're discussing was in line with Captain Frangos's intention. We have a quote from the transcripts of the trial from Miss Frangou's evidence where she says it reflected both of their intentions, and I can take you to that very quickly. It's at tab 7, page 102. And if you would like to read from page 74.4 of the transcript up to 75.2.
Sorry, give me the reference again.
Page 102 of behind tab 7, my lord, and within that it's panel 74 of the transcript, line 4, all the way to line 2 of panel 75, which is up.
And this is cross-examination of
Miss Frangou. Yeah.
So we have Angelica's evidence in cross-examination that the MEH letter's contents were intended by both of them. But does that take us far enough in the sense that we need to be able to imply, infer, whatever, an intention on both their parts that it should replace the previous arrangement?
It's never been anything other than part of Captain Frangos' case by running the implied rescission case in the first place, that it was his intention that the MEH letter would replace their dealings. Part of the whole context of the case below, which hasn't translated up onto appeal, is that Captain Frangos' view is that as soon as the Orion 3 was acquired in 2012, the parties had moved away from the TTA and had entered a new period of collaboration and then acquiring more and more vessels into this structure. And that's a different worldview to the one that Ms. Frangou has, but it's always been clear that his view was the TTA was effectively departed from almost ab initio. And that's where we come to my next point, which is by reference to the judgment at paragraph 27. I'm now moving away from Ms. Frangou's subjective views, but looking to other indicia around that support the intention that I'm asking you to infer in or around the date of the letter. This is to the situation. Actually, paragraphs 26 and 27 of the judgment would be a better place to start. This is discussing how in 2012 Captain Frangos sent 2 draft addenda across the line that purported to void the TTA. So I suppose, my lady, to answer your question, that's a good place to look for his intention. And they were never executed. But the draft addenda that go across the line in October 2012 are the last time the TTA is ever referred to between these parties until this litigation erupted. And we rely on that as significant context, and the judge returns to this theme at paragraph 90 of his judgment.
Under the estoppel argument.
And in terms that might seem reminiscent of what we were looking at in the Morris case, the first thing he says is the protagonists ignored the existence and effect of the TTA at all material times. Now, say that's significant. He goes on to explain no document passing between them acknowledged the existence of a contingent liability on the part of JF to cover any capital deficit. The TTA fell into a black hole.
But, so what? I mean, unless you're running a limitation defence or a estoppel defence, the contract is what the contract is in existence. If somebody wakes up, as long as they don't wake up too late to enforce it.
Alone, I agree, but this is one indicium that should be part of the analysis as at the date of the MEH letter and thereafter, that will feed into your judgment about whether or not the intention was that the parties had the intention that the TTA should subsist. And one of the contraindicators against an intention that the TTA subsists is the fact nobody's talking about it when these documents are being settled. If you had a contingent right under the TTA when you put the MEH letter together, or the 28 reconciliation that we'll look at, you'd expect there to be exchanges between the parties saying, oh, don't forget about this document, don't forget about my rights under this contract, no matter what we're setting down here, which leads me on to a point related to this, which is that in 2017, Ms. Frangou asks her financial controller, Mr. Miraclis, who you've heard referred to a number of times, to go through all of Ms. Frangou and Captain Frangos' financial dealings back to 2011 to prepare something called the private ledgers, which were meant to be comprehensive records of their positions between one another. And one of the important points arising out of that is that at no point during that inquiry does Mr. Miraclis find the TTA. Note, he does not include the TTA or its effects or its anything to do with its the rights that might be afforded to Ms. Frangou by it in the work of in this work going back to 2011. And my lords, just to show you that, because the judgment the judge didn't refer to it in his judgment, it's in the transcript behind tab 2 in the supplementary bundle. Sorry, in tab 7 of the supplementary bundle, on page 114. And it's at panel 141, line 18. Page 114 behind tab 7. Panel 141, line 18, through to panel 143, line 24. This is Mr. Miraclis' cross-examination, and I'm questioning him about this undertaking, this process he undertook.
Well, all he's saying is, I didn't find it.
He didn't find it, and then up at 143, I ask him whether Miss Frangou asked you to include it in the private ledgers, and he says no. I ask him, did Miss Frangou ever discuss the TT agreement with you? He says no. Now, like all of these things, I'm not saying any one of the indicia I'm drawing your attention to is the answer to my question. I'm drawing together different strands of the evidence so that you can understand the big picture. And we've got a contract that isn't referred to from 2012 onwards. We've got the MEH letter. We've got the evidence from Miss Frangou that you've seen about what she intended the MEH letter to achieve, which I say gives you passive information about her intention towards the TTA. And you've got her financial controller conducting a supposedly exhaustive review of the relationship between Captain Frangos and Miss Frangou, with nobody finding the TTA or being referred to during that process. And as you tie these things together, in my submission, the implied rescission case comes into focus.
But you have to be able to say that this state of affairs is only explicable on the basis that there was an agreement to discharge TTA, and that's the implication is a high burden. It has to be necessary, if you like, to make sense of what occurs.
Yes,
has occurred. I mean, there are other explanations which are pretty obvious in relation to any sort of just failure to mention an agreement. I mean, it just wasn't in the right place. People forgot it. X, Y, Z. It's at best a very slim further piece of evidence, isn't it, that nobody found it or referred to it?
Well, My lord, my case here rests on you drawing all of the different factors together and then forming a view about what was more likely. Looking at everything together in the round, is it more likely that the intention was that the TTA should be abrogated and departed from, or is it more likely that with all of the arrangements that were being put in place, at the same time they still intended the TTA to be waiting in the wings to afford Miss Frangou?
Do we, sorry, go back to where the judge actually decided this point. I mean, insofar as you were asking us to look at other factors, on that question, the judge is making a finding of fact, isn't he, as to whether there's an agreement or not. I mean, do we have to say that the judge reached a conclusion? I'm struggling to put this into a box marked either interpretation or existence of the agreement. What are we actually doing here?
Well, I think the question of ascertaining whether an agreement exists is still a question of interpretation of the relevant matters. It's
I thought you much earlier were saying that. I mean, the judge. The question is: was there an agreement to rescind the TTA?
Yes.
And that's not a question of interpretation. It's a question of, at first, is there an agreement? I mean, you can't point to a document by definition.
No.
I mean, so it's not a question of interpretation of a document.
Yes.
It's a question of, was there an agreement?
Yes.
And so the judge said, no, there isn't.
Yes, I mean, that was his decision, so I'm asking you to overturn that and say there was an agreement.
So do we have to say that either there was no evidence upon which he could have reached his conclusion, or that his conclusion was plainly wrong on the evidence, or what's the test?
It would be that it was wrong and that he didn't take into account the material factors that I'm addressing you on now, or didn't give them sufficient weight.
It has to be plainly wrong, doesn't it?
I think sort of everyone's moved away from the qualifying words around plainly or clearly wrong, and it's really just the question, a bit like my learned friend would say, is the test you need to apply to the instruction issues, whether the judge has got it wrong or not.
I thought when you're trying to persuade an appeal court to overturn the judge's finding of fact on the evidence, I thought it was still quite a high test.
I can double check, my lord, in a moment, but my impression is it's the same. The question of whether a contract's completed is a mixed question of fact or law, and it probably, it's a question of the judge taking into account various matters which evince an intention to create a contract. I suppose a notional offer and acceptance and an intention to create legal relations and consideration are all wrapped up into that concept. But
perhaps one has to subdivide a bit. I mean, the question of intention to create legal relations sounds pretty much like a pure question of fact, which one would probably apply the conventional test, which is this court won't interfere unless the judge has gone so obviously wrong that no reasonable judge could have reached a different, could have come to the same conclusion. On the one hand, on the other hand, if it's a question of was the consensus ad idem on an objective basis, that's much more like an issue of law, to which one would simply ask the normal question: was the judge right or was he wrong?
yes,
And that's not really a finding of fact at all.
no, my lord, I think we're in that territory.
You think you would say we're in that territory?
Yes. With 1 hour on the time and not wanting to cut into Mr. Hill's reply at all, can I just take you to the 2018 reconciliation, which I rely on both as post-contractual conduct to the implied rescission agreement I contend for at or around the time the MEH letter was concluded, and then I also rely on it in its own right as a more traditional contract too, which in itself discloses an intention to rescind the TTA. And the reconciliation is in tab 28 of the supplementary bundle. This is a document executed, or at least understood to have been executed on the 31st of December 2018. And the signatures you see in the right-hand column are those of Miss Frangou, Captain Frangos, and Mr Miraklis, the financial controller.
So
This
sorry,
is-
my fault. Which bundle are we in?
It's the supplementary bundle behind tab 28.
Tab 28.
The judge considered this document had contractual effect by virtue of the signatures, but you'll appreciate for my case it doesn't really matter whether that's right or not, or what sort of contractual effect it had, but it has some sort of formal status. And the key features of this document, I just need to talk you through this document for a few minutes to show you what eventually I say it means. So you've got the vessels listed along the top of the document horizontally. You've got all of the 6 vessels from the MEH letter, and you've also got a couple of others that the parties also co-beneficially owned as well, which you won't recognise. Those are the ones in the second, third along of the table, the Christine B, the Pacific Cebu, and the Hope 1. But the other vessels are the 6 from the MEH letter. And at the top line, top right, top left-hand corner, you've got a to be paid to Maren, to be received from Maren. And Maren is Mem, the manager. That's another shorthand the parties used to describe it. And what you have going along this line at the top are different figures.
So Maren is
Mem, the manager.
Angeliki's management company.
Yes, Mem, the company you see referred to in the TTA. And what you've got going along the top of the table are various figures. And these are snapshot figures of monies that either are owed to Mem by the ship-owning company, or that Mem, the manager, owes to the ship-owning company. So if you look for the Towers 2 in the first line, there's a minus 6.2 million figure. And that's indicating that at this stage, at this date, Brandon owed Maritime Enterprises that amount of money, or Maritime Enterprises had been funding Brandon's trading to a deficit of that amount. And you see the different positions in relation to the different vessels going across.
Right, the minus is rather confusing. They put right in the bottom left-hand corner. Is that right?
The minus, my lord?
I mean, it's almost invisible on my copy.
I apologise. Yes, it's right on the left-hand side of the box.
I might expect the figure to be put in brackets. Anyway,
I agree. That is a more traditional way of doing it, but this is how they did it.
I see. Thank you.
Yeah, and then as you go down, if we take the Towers 2 column as an example, as you go down the column, various adjustments are being made to the headline figure. And then you get to where the first set of boxes ends, you get to another description of to be paid to Maren, to be received from Maren, 31st of December 2018, so an adjusted figure. And there, for example, the TT is minus 5.8 million. And then as you go down into the next table, the next 4 or 5 row table, you've got some more adjustments being made to the figure you've just been looking at, which then comes to another final figure to be paid to Maren, to be received from Maren, of 6.66 million. So that's saying at that stage, as a snapshot at this time, Brandon owned Mem 6.6 million. And then as you go across the table, as has been the case all along, you have the various figures owed to Mem and owed by the ship-owning company, owed to Mem and due to the ship-owning companies, added and subtracted from each other to lead to a total figure. This is the process I say that's envisaged by the MEH letter, either subjectively by Ms Frangou or as a matter of the text of the document. And you come to a figure at the end of the row I'm looking at of 5.2 million, which I would suggest is the overall figure that the ship-owning companies as a whole owe to Mem as at that date. It's got a minus figure next to it. So they're in debt to Mem altogether to that amount. Then the critical part of the document, for my purposes, if you now go to the bottom row, which is titled Due by AF Final, and read along to the end of that row, so the bottom row of the table, Due by AF Final, read along to it, you get a figure of 2.647 million. That is 50% of the 5.29 million figure that I showed you a moment ago. So this line of the table is saying...
Sorry, wait a minute. Sorry, I understand the 5.294.
Yes. So half of that figure
You've
is
got old-
2.647.
All dues from JF.
Yes, so we'll come back to that in a moment. But if we jump from the 5.29 figure down to the very bottom line, the figure you see there, 2.647, is exactly half of the 5.294 figure. And the description of this line of the table is due by AF dash final. So this line is saying that due by AF to MEM as a final amount at this date is half of the sum that all of the ship-owning companies owe to MEM. My lords, this is consistent with what I say about the split in beneficial ownership that the parties agreed, representing who is ultimately obliged to fund the vessel company's losses to the manager or to Miss Frangou or to whoever it is. This is then putting into action the consequences of the split in beneficial ownership that I've been addressing you on. And what's critical is that the TT and the TT's Brandon's exposure to MEM forms the predominant part of the figure that Miss Frangou has agreed she is responsible to MEM for. So she is agreeing that she is responsible to fund 50% of Brandon's exposure to MEM as at this date.
Is it Brandon's exposure to MEM? Isn't it all of the vessels aggregated?
Which includes Brandon's. So as part of her agreement to bear the responsibility for half of all of their indebtedness to MEM, she's agreeing necessarily to also bear half of Brandon's indebtedness because its figures form part of that overall amount.
So how does this relate to how does it relate to the TTA?
So my submission is, my lord, if
Sorry, you said TT2, I think, didn't you?
the TTA is in the ship, yeah. But this is, we say this is inconsistent with the TTA because Miss Frangou is accepting here that she is ultimately responsible for 50% of Brandon's exposure to the manager. And her case under the TTA is that she is not responsible for any of Brandon's exposure to the manager because Captain Frangos is responsible for all of Brandon's exposures, accumulated trading losses and shortfall.
Hang on. You just cut a corner there, haven't you? The TTA, the agreement, requires John Frangos to pay to Angeliki an amount, I to her personally, which includes the indebtedness which Brandon would owe to MEM.
100% of it.
Right. Okay, so you're saying this is inconsistent with that because
she's agreeing to bear 50% of it. She's agreeing that's what her final, as at this stage, exposure is to MEM. Split, because if you go to the line up, it's due by JF. So his exposure to MEM is being dealt with. This is the splitting up of the exposures to MEM in relation to all of the ship-owning vessels, including ship-owning companies, including Brandon, agreed as between Captain Frangos and Miss Frangou. So how can it be reconcilable with her intention that she was entitled, that Captain Frangos had to pay 100% of Brandon's exposures to MEM to her under the indemnity, if she is accepting in this document that she bears responsibility to MEM for 50% of those losses? It's dealing with the same subject matter, and it is completely inconsistent with that 100% indemnity. And the judge's answer to this is that the TTA might be waiting in the wings still. So she's got this document where she's agreeing to be liable for 50% of what Captain Frangos is meant to be paying to her. But at the same time, the TTA exists in the wings waiting to come in. Because I suggest that was an illogical conclusion for him to reach to, not one for him to reach, not one that should have been open to him on the available materials. Because this is flatly inconsistent with Miss Frangou having had an intention at this stage, or in 2017, when the MH letter is settled, which is the precursor to the treatment of the funds that you're seeing in this document. It's inconsistent with her at the same time having intended that Captain Frangos was responsible for all of the losses.
And can you explain to us, help us, with the lines which are at the beginning of the second box, which are payments to JF, readjusted for AF, and then at a separate line, which is in its own box, which is old dues from JF.
Yes, so dealing with the old dues from JF, that is a recognition of other sums that Captain Frangos owed to, I understand, men, that are being brought into account in this document. So you start off with the figure immediately above that of the 5.294 million. 50% of that's allocated to Miss Frangou for the reasons I've been discussing. The other 50% is allocated to Captain Frangos. Then a whole series of other debts that he owes to men are being added on to lead to the total figure he owes to men, which is 7 million. So he owes a lot more to men because he's been, I don't know, I can't tell you the exact constitution of that money. It may be that it's derived from one of the other private ledgers, of which this is one of the 3 private ledger documents. So various adjustments are being made in this document to take into account, but the critical point is the treatment between the siblings of the exposure to men, which is flatly inconsistent with the precept of the TTA. And you've got to ask yourself, again, against all of the materials and indicia I've referred to you, can this, when you pull everything together, be reconciled with an intention that the TTA was still to subsist? Or had everyone departed from it? Had they moved on? Had it been left behind? Had things changed? Was there a new way of dealing things between them that is meant to be the vehicle for the resolution of this debt? And the overarching point of this case is that nobody's saying that Miss Frangou might not have a route to recover money she's entitled to genuinely in relation to the TT. The point is it's not under the TTA, it's under the infrastructure of the MEH letter, because that's what she agreed to do. Well, Lords, I'm looking at the time and I don't want to leave Mr. Hill with no time to reply to you. Can I just check my notes briefly to see if there's anything I'd like to finally say? My Lords, unless I can help you further, that's everything I wanted to address you on.
Thank you so much. Mr. Hill.
My lady, my lords. Unless you have any questions for me, I don't intend to say any more about the duration issue. And therefore, I'll just say move on to the durability issue. In relation to the durability issue, I only want to really just highlight one matter. In his oral submissions, my learned friend essentially read out 2 paragraphs of his skeleton. I noticed it was almost word for word, and I just want to show you those paragraphs in the skeleton. They're in tab 4 of the core bundle. At paragraph 60 and 61. What he said to you orally, and he essentially, as I say, read out what he's written here. Paragraph 60. If JF was wrong about the longevity of AF's Clause 5 rights, his alternative construction argument below was that, and these are the words, an essential predicate of Clause 5 of the TTA was Brandon owned 100% by AF. Thus, if that were to change, Clause 5 would cease to be effective, as no doubt would Clause 1 as well too. And then paragraph 61, if it is accepted that the premise of the agreement at the time it was concluded was that AF was 100% beneficial owner of Brandon, but JF remains 100% responsible for its losses, one is entitled to ask as a matter of interpretation, does a claim for 100% of Brandon's losses by AF at a time when she is only 50% beneficial owner and thus she is thus responsible for only 50% of Brandon's losses fall within Clause 5? Then he goes on and says, the answer is no. One can test the point in this way. What would the position be if, instead of relinquishing a 50% share to JF, AF had sold 50% of Brandon to a third party in 2015, and this is the point I'd like you to underline, who then agreed to be responsible for 50% of Brandon's losses. On AF's analysis, she would still be entitled to 100% of Brandon's losses from JF as at 2020. Now, with respect to my learned friend, the error in all of this is that he assumes that because you are a shareholder, you are liable going forward for 50% or 100%, whatever it may be, of the losses of the company. And he made good his case by saying, and my Lord Snowden picked him up on this, well, that must be right, because if the company wants to continue trading, the only way it can continue trading is if the shareholders add more equity, add more cash to the company. And that's the premise of his whole analysis on durability under Clause 5. What we say is that is wrong as a matter of analysis. If one takes up the Clause 5, test it this way. If we start with the simple case of a sale of the vessel by Angeliki, and at this point we're not worried about the time when it happens. Angeliki sells the vessel. There will, on sale, if the proceeds are not sufficient to meet the outstanding indebtedness to the bank and the accumulated losses, there will be a loss. Now, on sale, on the sale of the vessel, there is no reason why you'd want Brandon, which is a one-ship company, to continue in operation. There's absolutely firstly, there is no legal obligation on any of the shareholders to make good that loss. But secondly, there would be no commercial obligation on John if Angeliki at that point turned round and said, well, could you please contribute to that loss? Why would he say yes? And the same happens in relation to refinancing. If whatever date you take, if you refinance, and from the, say for example, we know in 2015 the vessel was worth $9 million. That's her market value, but there was a $19.6 million balloon payment to be made. You've got a $10 million, more than $10 million deficit. Why? Firstly, there is no, again, legal obligation on any shareholder of Brandon to pay that loss. But equally, if we look at just commercially, in circumstances where John has not been able to repurchase the vessel, and in circumstances where Angeliki has decided to refinance, why would John, if asked by Angeliki to make good that loss, or 50% say of that $10 million, why would he be interested in doing so? He wouldn't. Therefore, there is nothing inconsistent with the operation of the indemnity, even if she has divested herself of any of the shares in Brandon. But of course, the next point is she never did divest herself of any of the shares in Brandon, because all of the shares were owned by were held by MEH. They were in the name of MEH, and MEH has at all times remained the shareholder.
Yeah, but she divested herself of 50% of the beneficial interest in the shares.
She, yes, I accept that. But even more so then, why would, I would suggest, why would a potential beneficiary of a trust of the proceeds or the distribution of shares held by MEH, why would the ultimate beneficiary here, John, have any reason to voluntarily contribute on sale or refinancing the losses of Brandon, which is way up the chain?
Well, I mean, that may be so, but that wasn't the point I picked you up on. I mean, I just picked you up when you said that she hadn't, I mean, you said as if it was made any difference that she hadn't disposed of any of the shares. I mean, she never actually legally held any of the shares, but she did hold beneficially. And just
I agree with that. No, I agree with that. And then the final point I just want to make on durability is this. You saw from the document Mr. Fell produced overnight and we handed up, and there are only two categories of creditors. Oh, sorry, there are only two categories of so I'll put that in a different way. Yes, there's only two categories of creditors. There was the bank and there was MEM, the managers. Because all of the operations of the vessel were done through MEM. And therefore, at the end of the day, if the vessel was sold, or she was refinanced, there would always be only two potential unsecured creditors. But of course, the bank isn't an unsecured creditor because it's got a mortgage over the vessel. So the reality is, and also the bank has the personal guarantee of Angeliki. Therefore, in practice, the only potential creditor to this company, Brandon, at any time is Angeliki, either because she is forced to pay out under her personal guarantee and then has a claim against Brandon, unsecured creditor, or MEM is an unsecured creditor because of its incurring of the trading costs and losses of this vessel, which you've just actually seen in the reconciliation, 2018 reconciliation. They were the, and of course MEM, as you know, is wholly owned by Angeliki. And therefore, if one goes back to clause 5, it's unremarkable that the indemnity is to Angeliki. Because at the time when they entered into this contract, the parties foresaw that she was the only person who would be suffering the losses.
And I understand entirely why the indemnity would be in her favour for any shortfall, because that's her. It's slightly less easy to see it as a matter of law why the indemnity would be to her if the loss was suffered by MEM. I mean,
and the answer for that is, in practice, as you've just seen from the reconciliation, MEM is funding, is essentially acting like a bank account and funding the operations of all 6 vessels, all 9 vessels. And the reality is, to the extent that MEM isn't paid as an unsecured creditor, because MEM is Angeliki's company, she has to fund MEM to keep all of the fleet going.
well, she might or she might not. I mean, in the sense that it may be that MEM makes a lot of money on other companies, and so it effectively just writes off this loss. I mean, what would have been more straightforward is if the indemnity were, or the promise was to indemnify Brandon, which could then have made a distribution to its 2 categories of creditors, namely
The bank and
Angelika in a capacity as subrogated, having paid on the guarantee, she'd be subrogated, and MEM. I mean, that's in legal, in a strict legal sense, what would have happened?
we say no because well, probably no because in practice, the only way in which you're going to be able to sell the vessel is to clear the mortgage, because the loan's secured by a mortgage. The only way the bank's going to allow the mortgage to be cleared is somebody pays. And unless you can force John there and then to pay up the money so you can bring an end to your losses and get rid of the vessel, you're going to have to do it and claim off John later.
Well, you would just, I entirely follow that. If this clause had been limited to the shortfall, I entirely understand that. I mean, in the sense that the payment would be to Angeliki.
Yes.
Because she would need to pay up under the guarantee, effectively to
be able to
persuade
sell
the bank to release the mortgage on sale. So if this had been limited to shortfall, that's the route.
Correct.
Because it also picks up accumulated losses. The accumulated losses are suffered by Brandon, and in reality, therefore, because it's been fronted, to use Mr. Caplet's phrase, the losses are suffered by MEM.
Correct. They are.
You know,
you're right.
If you were writing this with a real sort of anorak on, you'd say shortfall payable to Angeliki and accumulated losses payable to Brandon, brackets, to enable Brandon to discharge his debt to MEM.
I agree entirely. And they didn't do that because the practical reality is, rather than give the money to Brandon on the sale or the refinancing, and then Brandon give the money to MEM, even though MEM is actually being funded by AF, because she's the one who, it's her company, she's putting the money into that company. They just short-circuited it, and they said the money goes to AF. But what my point is this, there is nothing in clause 5 that says that indemnity should only work as long as AF remains 100% beneficial owner of Brandon. And if that was intended to be the position, it would have been said expressly, and it's not the position, and you can't imply it. It's not said expressly, and you can't imply it. You can't imply a condition subsequent that's not on its face. To be fair, my learned friend never properly answered your question whether it's really a matter of construction or a matter of implication. And my learned friend says Gilbert Ash doesn't assist. We say it does assist. Simply, you do need clear words if you're going to deny somebody what is their contractual right of an indemnity. You'd expect there to be some sort of clear words that would say, which would say expressly, yes, I will indemnify you, and then it goes on, so long as you remain 100% shareholder, beneficial owner of Brandon. Mr. Feld wants to have a few words about quantum, but I'll finish off with, if I can, with implied rescission, and then I'll let Mr. Feld deal with my learned friend's quantum arguments. Can I just deal with, firstly, the law on implied rescission? Our position is straightforward, and we've set it out in our skeleton, and therefore I'm not going to labour the time this afternoon. It's in our supplementary skeleton, and you'll see it starting at page 90 of the bundle, tab 5, page 90, paragraph 4 onwards. Because you have what my learned friend calls contract 1, the only way in which you can rescind contract 1 by another contract that agrees that contract 1 is rescinded. You can do it expressly or you can do it impliedly, but implied rescission is a contractual doctrine. It's not an equitable doctrine. It doesn't pertain to looking for intentions and estoppels. It's a contractual doctrine.
I don't think Mr. Appellant disagrees with that.
No. And
it's just that he says that you're a bit strict because you say that you can only get that implied contract from the terms of another contract.
Yes, and what I say is, and it's a small subtlety, but what we say is you have to get that from another contract. Now, that second contract, there's only two, there's not three, there's only two contracts. That second contract has to be a contract. It doesn't need to be enforceable in all its terms. Now, the very good example of that is Morris and Barron. In Morris and Barron, the second contract was an oral contract. It was still a contract, even though, one, it was oral, well, principally because it was oral. It's still a contract. Now, it wasn't enforceable as a contract for the sale of goods. So the second contract provided for a fundamental change to the first contract and involved the sale of goods. And therefore, the parties couldn't enforce that second contract to the extent that its terms involved the sale of goods, because it fell foul of the Sale of Goods Act. But it was still a contract, so that part of the contract could not be enforced. It was unenforceable. But it was still a contract for the purposes of a parole evidence contract, for the purposes of implied rescission.
And do you say that neither of the two documents we've been looking at constitute a contract for this purpose?
I do, for this purpose. I say, in relation to the MEH letter, it's not a contract at all, it's simply a declaration of trust by MEH. In relation to the 2018, and that's the same view that the judge took. In relation to the 2018, it's a spreadsheet. It's not a contract. I'll come on to the detail in a moment. It's a spreadsheet of which, as the judge said, put at its highest, there is by both parties signing it, there is an agreement as to the facts, the figures contained in there, in the sense that, I think the judge put it, you're almost stopped from going back on, because you've agreed that those are the correct figures.
I think the way it's put by Mr. Capt, he says it's an agreement signed by your client, Angeliki, that she will contribute 50% of the monies due to MEM, including due from Brandon to MEM. And
yes, that's what he says.
That is he says that it's an agreement to that effect. I mean, it says on it, due by AF.
Yeah, and that's a misreading of the
number, and she signs it.
Yes, and that's a misreading of the document. And when I get to the reconciliation, I'll explain why that's just a complete misreading of the document. Right. Just on before, one more point on the law, or maybe two more points on law. Firstly, because the second contract has to be a contract, you need consideration. And that's we've dealt with it in our submissions. My learned friend didn't deal with it, but it's the Noga case in Abacha, and it's Lord Justice Tucky. You need consideration. And that goes back to the point that the contract might still not be enforceable, but it's got to be a contract and it has consideration. But it might not be enforceable because it falls foul of the parole evidence, the Section 4 of the Sale of Goods Act. The other point on law, my learned friend, as you will have seen, he can only make his case by praying in aid events after 20, in this case for the MEH letter, 2017. And he says, well, look at the 2018 reconciliation, look at the fact that nobody mentions the TTA agreement. And he also says, look at Angeliki's own evidence about the TT agreement, her subjective intention. And he seems to be putting this all on. You're entitled to look at post-contractual conduct to determine whether or not an agreement has in fact been reached. But that is with respect to my learned friend, that's a sleight of hand. The agreements that he relies on are there. They are the MEH letter. Its terms are there. They are set out. The other document is the 2018 reconciliation. It's there. The terms if it's an agreement, are set out, it's signed. You don't need to look at anything else to decide whether there's been an agreement. An agreement has been reached. And what he's really trying to do again is pray in aid in inadmissible material to construe a contract, namely either one, post-contractual events, or two, subjective intention. Now, that's the law. If I can turn to the MEH letter first, find that at tab 26. And it's important to recognise, and to be fair to my learned friend, he did, that the circumstances leading up to the MEH letter are hotly disputed. The judge heard some of that evidence and decided he did not need to resolve what the commercial purpose, as it were, of the MEH letter was. Now, we have essentially three reasons why this cannot be amount to implied rescission. The first one, we support the judge that it's simply not a contract between Angeliki and her brother. It is simply a declaration of trust by MEH. And that's just a simple short point. The second submission is that in any event, there is no inconsistency, fundamental or otherwise, the test is you go to the root of the contract, between the MEH letter and the TT agreement. They are more than capable of sitting alongside each other. And my lady made essentially the point we make in paragraph 17 of our submissions, which is what this MEH letter does is give Angeliki additional rights. All my learned friend really relies on is paragraph C of the letter. The first line takes him nowhere. That we shall keep both of you fully posted regarding any matters related to the above. That must be the holding of shares. That can't take him anywhere. And then, in particular, we shall not fail to take into account, insofar as the assessment and or distribution of profits or losses is concerned, just pausing there. So that bit is saying no more than what's set out later, we will not fail to take into account in all our dealings with the trust assets. So what is it that you won't fail to take into account? It's any proven unequal cash contributions in the form of equity or loans by any of you or your affiliates, or advances by the managers in relation to any of the ships which might be disposed of at a future stage, such assessments and or distributions to be verified by independent auditors. And then, and it's important to look at the next bit, advances unrelated to any of the ships made by any of you to the other may be taken into account in the above assessment upon the request by the party that made the advance. So what it's really saying is we will not fail to take into account any of those matters if and to the extent that there are distributions made from any of the vessels to MEH, and then MEH has to account to the beneficiaries for those distributions. That's all it's saying. It's not. It's not. One, it's not inconsistent. But secondly, and more importantly, it's just giving her extra rights. What?
Extra rights? Or is it just a statement by the trustee to say this is what before I make a distribution to the two people or two companies on whose behalf I hold the shares, I'll take into account any contributions, any loans or other things that you may have made between you.
And a good example is.
I mean, she doesn't actually. I mean, unless this is put as not a distinct alternative to your first point, this isn't a contract between AF and JF. This is, you just say, a trust document, a document by statement by the trustee. And I'm slightly surprised you then start talking about that.
Right.
She has rights.
Yes. What it's doing. Well, let me say this. What it's. Let's do it by a hypothetical, an example. What happens if she calls on her guarantee, on her indemnity, and John doesn't pay? If John doesn't pay, it gives her some comfort. But rather than say rights, it's extra comfort, because what this is saying is, if he hasn't paid, then that is one of the factors that MEH is telling both beneficiary companies that it will take into account when making a distribution of the trust property. And not even it must do. Can I make this point? It's not saying it must do. There's nothing in this document that tells you how you're supposed to do it. It's just won't fail to take into account. It's some extra comfort. That's all it is. So, noting time, I better go on to the reconciliation. Just before, can I ask the court to turn over the tab to tab 27? My learned friend mentioned a number of reconciliations. Oh, sorry, can I just interrupt myself? Before I do that, I did want to show you a bit of the transcript that my learned friend did not show you on that last point I made. If the court can turn to tab 7 and have a look at page 103, my learned friend asked you to read various pages on 102. If the court can just read on a bit more, and if the court can read page 100 of the transcript, page 77, 103 of the bundle, and can you read the answer at lines 4 to 21? And because my learned friend read parts of her statement to you, I say it's all admissible because it's subjective, but if you're against me on that, you should also have lines 4 to 21 in mind from page 77 of the transcript. I'm grateful. I mean, I say it's all inadmissible because it's just subjective intention and it doesn't assist you at all as to what the MEH letter means. What it means is what it is on its face, not what some party says about it. If I go on to the 2018 reconciliation, the documents at tab 28, but before we get there, can you just have a look at tab 27? My learned friend fairly said this was tab 28 was a number of reconciliations between the parties, and you'll see at tab 27, there's one earlier in the year on the 7th, you'll see the date on the bottom left-hand corner, 7th of February 2018. And this is a reconciliation that was done at that time, and you'll see this one is headed Agreement between Angeliki Frangou and John Frangos. That one's actually described as an agreement. What's noteworthy, and I'll explain why, is when one goes over the page to tab 28, this isn't headed an agreement because it's not an agreement at all.
The form. Oh, okay. Okay. Yeah, go on.
So you have three parts. Can I just deal with what the top section of this document shows? The top half of this spreadsheet shows the cash position as between each of the vessels and the manager, MEM. In effect, it allocates the total cash received and dispersed by MEM during the period, December 2017 to December 2018. You'll see the dates on the left-hand column. The top one is December 2017 and the bottom is 2018. And what it does, it allocates the total cash received and dispersed by MEM during that period for all the vessels under MEM common management. This is a snapshot, and this is the important point. It's a snapshot allocation of the total cash available to MEM or MEM's total indebtedness if the figure is negative between each of the vessels as of December 2017 at the top and then December 2018 at the bottom of that section. Such a cash flow reconciliation was necessary because, as you've heard, MEM was the manager of the fleet essentially pooling all the cash. The reconciliation, we say, says nothing whatsoever about the trading profit or losses of the individual vessels or the fleet as a whole. The reconciliation simply shows the cash available to the fleet, the positive and negative entries for individual vessels simply showing whether the ship-owning companies had drawn cash advances from MEM or paid in cash surpluses. So what it's not is a profit and loss. It's not a P&L account. And the point could be illustrated as follows. Imagine if one of the vessels had earned a very large sum of money in hire, so it was very profitable, but it had not been paid that hire by its charterer. It will not have the ready cash, and it could not therefore pay its trade creditors. Therefore, MEM will be using cash received on account of other vessels. So it's not telling you anything about the profitability or the profit or loss of any of the underlying ship-owning companies or the vessels. Further, it says nothing about the capital gains or losses. It's no more a balance sheet than it is a profit and loss account. For example, the reconciliation, if you look at it for Brandon, takes no account of the balance sheet items in Brandon's accounts as at the 31st of December 2018, such as Brandon's loan liability to HSH of $23 million at that time, and the unpaid trade creditors at that time. The negative figure in the reconciliation for Brandon's cash liability to MEM, as at the two dates, December 2017 and 2018, therefore has no logical or other connection to the shortfall or accumulated losses referred to in clause 5 of the TT agreement. They're apples and oranges. Therefore, my learned friend is wrong when he submitted to you earlier this afternoon, and he says it, he basically read out again paragraph 77A and C of his skeleton. He's wrong when he asserts that the reconciliation purported to allocate trading losses of the MEH fleet, vessels, or the financial performance of the collective fleet. It was nothing of the sort. And what John seeks to do is undermine the findings of fact made by the judge, and he finds expressly, expressly that the propositions that I've just explained to you was the underlying basis of this document. Now, the middle section if one looks at the middle section, then this adjusts the cash liabilities to MEM, take into account withdrawals from MEM made by John for his personal benefit. They're taken as advances of any distributions due to him. So he had a lifestyle that needed to be funded, and he took cash advances in advance of distributions to be made to him in due course, and they are recorded there. John had drawn some 2.352 odd million from MEM for his personal benefit as purported advances on account of distributions to him, and the sum is found in the far right hand column on the line payments to JF. You'll see the figure there.
It seems to be matched by adjusted for AF.
Yes, and that is because, and this is the evidence, I've set out the evidence in our skeleton argument. I don't have time to take you to it now, but John said, I'll only sign this document if you notionally agree that you took the same amount of money as well. And Mr. Miraculous gives the evidence of that. And what happens is that to get him to sign this document, she was content to have that recorded. And if you, just so that you know where it is, you'll see that in our skeleton argument. Just give you the reference to it. Yes, here it is. It's on page 100 of the core bundle.
Paragraph?
Subparagraph G, the main paragraph, paragraph 20, subparagraph G on page 100 of the core bundle in tab 5. You'll see the references there. And then, as we say here in this, while we're in the skeleton, I'll show you, the final section of the reconciliation then allocates the total cash funding requirement at the end of, at the end of the middle section, equally between AF and JF. That's why the entry due to AF final is precisely 50% of the 5.294 million odd at the end of the middle section. And the entry due by JF is a lot larger at 7 million odd and comprises the same 50%. Now, why is this document not an implied rescission of the TT agreement? Again, three reasons. One is it's, we may as well just take it from my skeleton here, it's a short point. First one is that paragraph 22, it's not a contract capable at all of giving rise to an implied rescission. It's not a contract in any meaningful sense, it's a spreadsheet. And beyond the fact that it is signed, there's nothing that suggests it was an agreement to achieve anything. We say at most it is a solemn record of the financial facts. We say it's certainly not a document from which you can start to infer an intention to alter still less change existing contractual obligations under the TT agreement. And then my second point is there's no inconsistency between this and the TT agreement. The reconciliation says nothing about the profits and losses of the vessels. And I've made that point. It's nothing to do with clause 5 and the shortfall and accumulated losses from trading the vessel. It's simply a cash position. It's a snapshot on a day. Therefore, what we say is, my learned friend's submissions proceed from a false premise that actually the reconciliation is dealing with the same subject matter of the TT agreement. It's simply not. And my little C on the top of page 102 is the reconciliation, if the reconciliation amounted to an agreement at all, and as you know we say it doesn't, it could at most be an agreement that AF and JF should cover any cash shortfall of MEM pro 10 on an equal basis. That's all it is. Well, what the parties are doing by signing this is, at best, look, we've got to pro tem cover this cash shortfall. And that's how it will be done. And our third point is at paragraph 24. The TTA agreement did not amount to an agreement to split even MEM's cash funding requirement because it was prepared on a false or notional basis. And that's the point I've made orally to you already just now in relation to the sum due by AF, which comes from the evidence that I highlighted in subparagraph G on page 100. So what we say is there's nothing from any of this from which you can conclude, importantly, not what is more. My learned friend put the test as what is more likely than not. He said the test is whether it's more likely one thing than the other. That's not the test. What you've got to be able to do with respect is conclude that there is a clear and unambiguous intention in the what we would call the second contract, that the first contract is no longer in existence. You simply can't conclude that at all, with respect, we say. Unless, I'm sorry to go over 5 minutes, unless I can assist the court any further. Those are our submissions.
Thank you very much. Worse than 5 minutes because we have Mr. Feld to come, but there we go. Mr. Feld.
My negative 5 minutes, my lady. Trespass on your patience. Just a couple of points on Orion 3. Paragraph 81.2 of the judgment, so tab 7, page 131, the collateral agreement. My Lord Snowden asked whether there was a more accurate formulation or specific formulation of that agreement. There is one. It's in my learned friend Mr. Captain's closing submissions, and that is in the unagreed bundle, although my learned friend has said he's not going to object to me referring to it. Tab 2, page 69, paragraph 36 of the written closing.
Tab 2, page
69.
69. And paragraph...
36.
Thank you.
And it says, having agreed the principle on or around 15th of October from 21st June 23, JF and AF treated the economic fates of the TT and the Orion 3 as being intertwined, such that the profits of one would be set off against the liabilities of the other in any overall accounting between them concerning the vessels. So the collateral agreement there proposed was a personal agreement, a personal accounting between the two principals, taking as its inputs the profits and losses. So it was all bound up with Millennium Friend's case on the genesis of the MEH letter. And that is the agreement the judge is dealing with when he talks about an agreement between the ultimate principles of the mixed allocation of accounting and trading income. And he rightly pointed out that has nothing whatsoever to do with the indemnity in the TTA, because it has nothing to do with Brandon's losses, which is now common ground that responds to. That's a personal accounting between the principals. And the only way it can have an effect on this claim is if there'd been a counterclaim or a claim for an account leveraged by way of set-off against the sum due to AF under the TTA, but there was no such claim. Now that's fundamentally different from the case that's advanced in Millennium Friend's skeleton argument, which is to say that Trinite was a debtor of Brandon, i.e. that there was some contractual or other relationship between the two companies whereby there was an admixture of profits. Now, there's never been any evidence of that whatsoever. And indeed, it's clear from 81.2 that the judge wasn't making any factual finding about that, because he says the net trading losses wouldn't be reduced to reflect any income received, if indeed so received or credited, from Orion 3. So he clearly wasn't making a finding as to whether any income went from Orion, from Trinite to thing, or would fail to be credited. And indeed, the idea that there was, via the cross-collateralization, directly between Brandon and Trinite, some mixing of profits or some debts between them is nonsense, because the documents that form the parties entered into formal documents setting out that cross-collateralization, and they make clear that Trinite was not obliged to pay any money to Brandon. Now, I really don't have a lot of time, but I would like to have assisted the court just on how one reads those documents, because they're complicated. But I'll just show you what they are for your lady and lordship's notes. So then the supplemental bundle, the first document's at tab 21 of volume 2. And this is a term sheet sent by HSH to Angelique, but importantly, if one looks over at 444, it's countersigned by John. So he was aware of those terms. And this sets out the whole structure of the deal, which is then implemented. So you'll recall that the context of this is that there was originally a large loan of 47.5 million to Shipping Fortune. There is then instead the Brandon loan of 26.8 million, which is secured by a mortgage on the vessel. And then there is then the Stiliani loan, which is the residual sum of John's original loan to the tune of 14 million. And that's an unsecured loan. It's only secured, say, secured by John's personal guarantee and an assignment to the bank of a claim that John's company had against the former charterer of the vessel. And if we look at the very top, dear Angelica, dear Billy, we'd like to summarise the main terms discussed up to now for the part financing of the purchase of the Panamax bulk carrier MV Navius Orion, which became Orion 3. It says, then at the bottom of that first paragraph, we note that Messrs Stiliani and Mr John Frangos will have to agree, and therefore they have to duly countersign. Background. The outstanding unsecured debt of Messrs Stiliani, guaranteed by John Frangos, the residual debt, so that's the Stiliani loan, not the Brandon loan, and that's 9.6 million. And the next 3 bullets recite the assignment of what's called the Bartia claim. This is the claim against the charterer as security for the Stiliani loan. Then we get to the 5th bullet, hence assume that all funds paid by Bartia and applied as prepayment to the residual debt, the Stiliani loan, would create a residual unsecured debt of 4.6 million. Next, in order to enable Messrs Stiliani to recover the remaining 4.6 million, you intend to buy the Navius Orion on behalf of John Frangos, which operating profits and equity value shall be used to further recoup/prepay the residual debt balance. The profits there are used to pay down the Stiliani loan. Nothing to do with the Brandon loan whatsoever. It's not mentioned here. And then it records here that what's going to happen is that a part of the security for the Stiliani loan in the form of the assignment of funds from Bartia are going to be used to partly finance the vessel. So in effect, HSH is investing a little bit of the money it would get on the Stiliani loan to buy a profitable vessel, which profits and capital values can be used to help it recover the Stiliani debt. Again, nothing to do with Brandon. And then over the page we had the detailed terms. A and B recite the use of the Bartia funds, and C. D records what then becomes the Trinite loan, which says we're going to lend you 9.3 million to help you buy the Orion 3. If we go further down, so it's in the middle of the 2 hole punches, there's no dividend payments, the vessel to be fully controlled and owned, either directly or indirectly, by Angelique Frangou, and the vessel to be managed by a management company owned or controlled by her. That ends up being MEM. Now this is the most important part here. Payment of minimum $1 million of any accumulated net profits from the operating of the vessel after 2 years, and a further payment of another $1 million after 4 years to be applied towards prepayment of the residual debt, Stiliani loan, payments to be covered by the personal guarantee of Angelique Frangou. Yeah, and if they don't come up to that, then Angelique Frangou has to make good the difference. Then we have a bit of the cross-collateralization, the second ranking mortgage over the vessel to be provided as security for the residual debt. So then there's going to be a second preference mortgage over Orion 3 as security for Stiliani. G, there's going to be an amended standstill agreement, so it's going to change the terms of the existing Stiliani loan, and H, cross-collateralization with Taurus 2. So this is all about the Stiliani loan, nothing whatsoever to do with the Brandon loan.
So the personal guarantee that's referred to of Angelique Frangou, that's a different personal guarantee.
Precisely, yes. That's a personal guarantee of Trinite paying a certain amount of profit towards the Stiliani loan. And that essential agreement is put into place in the finance documents. And I can't take you through all of the details, we don't have time. But the next page, I'll just tell you what they are and what the important clauses are. Tab 22 is a new settlement and standard agreement. It's effectively a restated Stiliani loan. And the most important clauses here are recital O on page 449, which effectively summarises what I've just shown you, i.e. there's going to be a trinite loan, the profits of trinite are going to be used to repay the Stiliani loan.
Sorry, give me the reference again. It's two.
Yes, sorry, it's recital O on page 449. Now, unfortunately, it uses lots of defined terms, and you have to go back through all the recitals to identify them all. But it essentially says the same thing as the term sheet that I've showed you. And I'm happy to take longer to show you, but I'm just worried about the time. The other important clause is over the page 451, 3.1, which says, following the request of the borrowers, trinite, the guarantors, and the credit parties agree that, and these are the three key things. Firstly, there's going to be a trinite loan. So this is A, little I is the trinite loan. Little 2 is the operating profits of equity value in the case of a sale by trinite of the new ship, that's the Orion 3, to repay the remaining balance of the loan indebtedness in the new loan agreement. You have to look back at it, but that's the Stiliani. And then this, the use of the assigned Bartia claim is used as an equity contribution. And the final relevant clause here is clause 4.1 F, G, and H. So that's over the page at 453 and 454. And that describes what Melania Friends called the cross-collateralization. Now again, I'm just going to describe it shortly. Hopefully you'll be able to read this in the documents. So, Trinite borrows the money to purchase the Orion 3. There's first preference securities to secure that, which is a mortgage on the Orion 3 and an assignment of the earnings of the Orion 3. There are then second preference securities, which are in G, which is a second preference mortgage on the Orion 3 and a second preference assignment of earnings, and they secure Trinite's obligation to repay the Stiliani loan or provide its profits with the Stiliani loan. So that's not quite right, sorry. Trinite guarantees this repayment of the Stiliani loan, and those second preference securities secure that. And the final element of the cross-collateralization is then a third preference mortgage over the Orion 3 and a third preference assignment of the Orion 3's earnings, and that is given as security for Brandon's obligations under the Brandon loan. Now that's the high point of my learned friend's case, which is basically there's a third preference assignment of Orion 3's earnings as security for Brandon's repayment. Now there is absolutely no evidence, there was no evidence at trial that that assignment was ever called upon, but if it was called upon, it obviously would have gone into Brandon's accounts. And this is an official document, this isn't some collateral side agreement. But there's no evidence that actually that security is ever called upon. And the same order of securities was then created on the Taurus 2 as well. So Brandon loan secured by first preference mortgage on Taurus 2, second preference mortgage securing Stiliani, third preference mortgage securing Trinite's repayment of the Trinite loan. That's the cross-collateralization. None of that amounts to anything like an obligation upon Trinite to pay money to Brandon or loan money to Brandon. It's just not there. And nor is that supported by any collateral agreement, because I've already showed you what the nature of the collateral agreement was. That's one document. Final document is at tab 23, and the key clause that adds, I mean, a lot of this is repeated, but the key clause is clause 18.8, and that's page 515 to 516. And that shows there the earnings recapture on the Orion 3, and that shows that the obligation of Orion 3 or Trinite to pay out of Orion 3 earnings those £2 million instalments against the Stiliani loan. But again, nothing about the Brandon loan. my lady and lordships, thank you for your patience. That's all I have to say.
Thank you very much indeed, everyone. Everyone who has spoken before the court and everyone who has done a huge amount of preparation in regard to this matter, and we're very grateful for your help. As you may be relieved to know, we're going to reserve our judgments. Oh, no, I have mine here. And they will be dealt with also on the usual basis, which you will also understand. I must draw to your attention the embargo on a draft judgment or judgments which are sent out, and we take that, as you will know, very seriously. And you have provided email addresses of those who will be within the circle of people to whom those draft judgments will be circulated. You'll also be fully aware that we would like assistance in relation to if there are typographical errors, etc., but we would not like assistance in the form of further argument of the case. And lastly, as you will also know, all consequential matters we hope you will be able to agree. And if you cannot agree, please make very short written submissions, and they will be dealt with by the court on paper. I think that covers everything, and I'm very grateful. Thank you very much indeed.
Thank you very much.
Rise.